In this segment, we're going to be talking about what's known as intellectual property. Intellectual property is an ownership interest in information or knowledge, which includes patents, which are protection for an invention or a design or a formulation or other type of creative process involving manufacturing or other similar things. That could also include protection for bioengineered agricultural products, seeds, and that sort of thing, and in some cases bioengineered formulations. So patents protect inventions, devices, designs, formulations, and those kinds of things. Other types of intellectual property include trademarks, which is protection for a brand name, a logo, which could include like the Nike swoosh or other type of brand products, the name of a business. And that could include a color, such as pink for Owens Corning fiberglass, or it could include a sound, like the sound when you log onto your computer. It makes that little jingle, or like NBC, dun, 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 those kind of things. And then we have copyrights, which are protection for a literary work, which could include books or music or a movie or other type of literary or creative works of that nature. So the big three are patents, trademarks, and copyrights. So when it comes to protection for intellectual property, there are multiple components that are involved. First of all is what defines the rights of intellectual property under municipal law. That is domestic law of the state where the creation was made, or where the invention originated, or where the business is located for a trademark. And essentially these rights are created under domestic law. The domestic law has to comply, if you're a WTO member, with the minimum standards that are established by the WTO, such as 20 years for a patent. In international law, the role of international law is to establish through IGOs and NGOs protection of intellectual property based upon state law on an international level. And international law has created systems to be able to file for what amounts to international patents and other intellectual property rights. And this is also part of the WTO TRIPS agreement, trade-related aspects of intellectual property, whereby WTO members, as a requirement of being a WTO member, must have their domestic laws, their municipal domestic law, in conformity with WTO minimum standards. So let's take a look at copyrights, first of all. So a copyright is a protection for a literary work, which again may include a book or music or a movie or a play or other type of creative painting. Nowadays we have NFT, non-fungible tokens, and other type of crypto assets involving intellectual property. So the idea of a copyright is protection for the author of the literary work. Under the Berne Convention, which is an international treaty involving intellectual property, this coincides with WTO requirements. Copyright lasts for 50 years following the author's death. And that establishes a minimum standard so that, for example, if I write a song or a book, I will have, during my lifetime, rights to that. I can control how it's released. I can get paid royalties if people want to utilize my music or my book or my painting or other type of literary works. They'll have to enter into a royalty and licensing agreement with me and pay me royalties. So a copyright, life plus 50 years of protection. And again, as I said, under the World Trade Organization, trade-related aspects of intellectual property rights, otherwise known as TRIPS, requires WTO member states to comply with the provisions of the Berne Convention. That means that the WTO members have to provide in their own domestic law the same minimum standard of copyright protection for a minimum of life plus 50 years. So that's part of what the WTO organization does, is to monitor the states that are members to make sure that their laws are in compliance with the Berne Convention and the minimum requirements of the WTO. And this also allows for, under the WTO dispute resolution system, if a country believes that another country's laws are not in compliance with the Berne Convention and the WTO rules, then they can file a grievance with the WTO and go through the consultation panel and appellate proceedings of the dispute settlement understanding and the dispute resolution mechanism of the World Trade Organization. So the next type of intellectual property right is a patent. A patent is a right to protect new, non-obvious, and useful machine, articles of manufacturing, composition, processes, which may include design patents or utility patents for a product of some type, in electronics, or, as I've said before, bioengineered products in certain cases, formulations, pharmaceuticals, and other type of products. Patents, again, are governed by various different international conventions and treaties, and are part of the World Trade Organization protection requirements. This includes the Patent Cooperation Treaty, which is administered through WIPO, which is the World Intellectual Property Organization. And this provides for filing of a single international patent application, which has the same effect as a national application. In other words, you file with the Patent Cooperation Treaty requirements through WIPO, and then you will have international patent protection for those countries that are part of the WIPO arrangement. Under the WTO requirements, a WTO member requires that the term of a patent be no less than 20 years. So this, for example, here in the United States, prior to I think it was 95 or 96, I don't remember exactly, but our law here in the United States used to only provide for 17 years of protection for a patent. When the WTO was created in 1995, the United States obviously became a member, and at that point we had to modify our law here in the US to go from 17 to 20 years to comply with WTO requirements. So this is, again, part of the WTO process, whereby if there is a country that's a WTO member that does not provide for, in their own domestic law, a minimum of 20-year protection, then other countries may file a dispute to have that country modify their law to comply with WTO rules under TRIPS. From an international standpoint, patents and enforcement of patents under the Berne and Paris Accords are governed by the World Intellectual Property Organization, WIPO, which is, this next slide down, headquartered in Geneva, Switzerland, and it's one of the 16 specialized agencies that comes out of the United Nations system as an IGO. And the purpose of WIPO is to administer, there are 23 international treaties dealing with different intellectual property components of patents, trademarks, and copyrights. And the general idea is that when you file with the World Intellectual Property Organization, that will grant you international protection for your intellectual property, primarily in the area of patents and trademarks, and to a degree, other intellectual property, to be able to have that international intellectual property protection. Trademarks are any word, name, symbol, device, or other identifier of a business or a product, which may include a color, a sound, could be a shape, like the shape of the Coca-Cola bottle, or the shape of other type of bottles for products, a sound or a musical theme, or a logo, or a jingle, whatever you want to call it, are provided protection. And typically under WTO rules, under TRIPS, a WTO member must provide for a minimum term of at least 7 years of property protection for a trademark. Now under US rules, it's typically 10 years for that type of protection, but you can renew that, of course. Trademark and copyrights, both of them are the type of first to use, first in time, first in right. And so with a copyright, if I develop a musical piece or a book, I automatically have copyright protection, but I need to register it with the U.S. Patent and Trademark Office, and then potentially with the intellectual property organizations for international. Same thing with a trademark. A trademark, you have first right if you are the first entity or person to utilize the trademark in the stream of commerce. And that's something that you want to be able to establish if you do have a trademark for a brand name or a company name or whatever. You want to be able to establish the date when it was first used in the stream of commerce and develop an intellectual property file so that if you ever need to prove in court or other type of a hearing when that trademark was first being used, you have the ability to do that. Now that could be in the form of a website. You're going to want to keep track of when the website first went live on the World Wide Web. Perhaps you could send yourself an email with the date, take a picture of it with your iPhone or your Android phone to establish a date time stamp. Or of course you could file it with the U.S. Patent and Trademark Office. States also allow for trademark, like here in Oregon, you can file for a trademark within the state of Oregon. It's only good in Oregon. But that's an ability or a way that you can establish the date from when the protection will begin. So when it comes to international law, under the World Trade Organization, as I spoke with the TRIPS requirements, this was one of the ideas for the TRIPS requirement is to allow for and require member states to harmonize, that is, make their laws the same when it comes to intellectual property. And the idea there is to cut down on counterfeiting and pirated goods, like fake Rolexes and Louis Vuitton bags and that kind of thing, and to allow for enforcement internationally, both by the holder of the intellectual property right, but also by member states to be able to bring an action with the World Trade Organization to contest or file a grievance in the event a country is not maintaining or properly recognizing intellectual property. Now, this is a constantly changing area of law, but for the most part, this has been an area where the WTO has done a really pretty good job of establishing these minimum benchmarks and creating the process for enforcement against WTO members that may be out of compliance with their own domestic law. So transfer of intellectual property is typically done through what's called a licensing agreement, and this is typically a contract with the holder of the intellectual property, be it a patent, a copyright, or a trademark, and will be a contract that will allow another person or entity to utilize those intellectual property rights. So for perhaps if I have a patent on a machine, I could license that out for other companies to build the machine and sell it. Or if I have a logo or other trademark like we see in sports, for example, you have the Western Oregon Wolf, the U of O Ducks, the Oregon State Beavers. Of course, NFL and other professional sports teams will license their design and logos for clothing manufacturers, and then they'll have to pay what's called a royalty, which is a fee that's paid to the holder of that copyright, trademark, or patent for use of that intellectual property. And if that fee is not paid, or if you're using the trademark, copyright, or patent, you're subject to potential criminal penalties, but more often it's done through civil lawsuit for enforcement of the intellectual property right. And that can lead to a judgment in court for monetary damages, for unjust enrichment, for lost profits by the holder of the intellectual property, perhaps a musician that did not get royalties, or pirated movies, and also a cease and desist order from a court ordering that be discontinued. And that can be done at an individual level. And then once the judgment has been registered, that can be registered internationally for enforcement. So this gives a right of direct action against a violator of the intellectual property rights under international law. And that will be the end of this segment.